Are you thinking about doing a K-1 fiance visa? Or today I'm going to talk about 3 main ways that people's K-1 green cards eventually get denied. We're going to break down each 3 parts, but before that, please like, subscribe to get more information and updates about the immigration process, and also download the no-cost Ultimate Marriage Green Card Guide for a breakdown of the entire process so you're very familiar with it and ready to strategize and handle a marriage immigration case. All right, thank you everyone for joining. Today we're going to talk about the K-1 fiance visa, and this is when a U.S. citizen is engaged to a foreign person and they want to bring them here so they can get married in the United States and apply for a green card there. The K-1 refers to the visa that gets them here, and then once they're here, they follow what's called adjustment of status, the green card. I might call it quickly K-1 green card, but they are separate things. So let's talk about 3 top reasons I see why people get these cases denied. Now, should it be denied? I've never had a denial K-1 case, but I get phone calls from people who do it, emails, and I see the issues they had. They also review the appeals and court cases related to K-1 visas, and I see what's popping up, and I've been able to identify the 3 main reasons people mess up in these kind of cases and problems emerge. So let's jump with number 1. Not including an intent to marry letter. So what is this? When you're filing the form I-129F, this is the first step when you're applying with USCIS for your green card to prove that the relationship is real. In addition to filling out the form, in addition to proof of your relationship, in addition to having documentation that you met each other, you have to include a letter that shows your intent to marry within 90 days of entering the United States. That's one of the requirements of the K-1 to get the green card, is have a letter of intent to marry in the United States. And this letter says, I'm single, I'm able to marry, and I plan on marrying when I enter the United States, as well as a U.S. citizen writing, I'm single and I'm able and I'm going to marry within 90 days. This is a requirement. Now, it's a very simple letter. It's like a couple of lines for each person's relationship. You think it's not a big deal, but a lot of people aren't aware of it, and they submit their case, and it gets denied for not including it. Now, what I've done in the Ultimate Marriage Green Card Guide, I talked about the no-cost guide that strategizes a marriage green card case. In the appendix at the end, I have samples of how this letter looks, so you could view that, get an idea of how it looks. It's what I use. I just change the people's names and they sign it, and it's all good. Just go to www.marriageimmigrationlaw.com and download it there, and you'll be able to take care of it. Okay, so that's the first reason, not including the intent to marriage letter. What's the second main reason I see people getting their green card cases denied? Well, this is kind of annoying, but there's 3 parts where they look about your relationship. There's the I-129F, the first part of the case with USCIS, prove your relationship. They look to see whether you're really a couple. There's a second part at the embassy where they review it, and a third part at adjustment of status after you get married and you apply for a green card. The issue I'm about to talk about right now usually happens at the second part, the embassy part, where they call into question whether this is a real relationship. I haven't had this problem with USCIS either at the I-129F phase when you're starting it, or at the adjustment of status part when you apply for a green card after you're married in the United States. But what I've seen is the embassies sometimes come back and say, I don't think this couple is a real couple. And then they send the case back, essentially they deny it. And so it's a really obnoxious thing, and you really want to be prepared for this. I usually find this happen at certain embassies that are considered high fraud embassies. So I see this in the Philippines. I'll see this in Pakistan, for example. I got a recent call from someone, I think Cambodia, who had this issue. So around that Southeast Asia edge is where I see most of the time when they deny the case for not believing its K-1 is a real relationship. But it can happen to anywhere. So you really want to be prepared and have your documents in order to be able to prove the relationship is real. So, communication records with each other. If you've seen each other, which you have to at least once, photos together, letters from family and friends, any sort of financial stuff that you have together, any sort of trips, if you went on vacations together, have the stamps in your passport showing where you went, the copies of the tickets to show, you flew in one plane or you flew to meet each other. And anything else, your engagement ring receipts, all this kind of stuff, anything you could do that shows the relationship is real, put it together, personal affidavits, breaking down your relationship and why you fell in love, all this kind of stuff, including the initial application, have some updates and take it with photos and all that kind of stuff to the embassy interview and be prepared to talk about your relationship. That's it. Usually it works. I've never had a problem, but I do get calls from people who have this issue, and that's the last thing you want to do after you went through all the weight with USCIS to get the case all the way to the embassy, and you appear for the embassy, you spend all this time, money, and you're waiting to see your loved one. You don't want to get denied for something like that. So that was reason number 2. And let's jump to reason number 3. I see people get these cases denied, and we're moving to the third part. So we started with the I-129F. I see an error there. It gets it denied. The second part with the embassy. And now the third part. You get the K-1 visa. You fly to the United States, a foreign person, and you go do a marry in the United States. Well, for applying for a green card in the United States, adjustment of status from I-485, if you're doing a K-1, you're required to get married within 90 days of entry. So within the 9 days after you enter, you have to get married. Then you file for adjustment of status, the green card application. Now, the requirement in the 90 days is only that you get married. You could file the paperwork for the green card after the 90 days, but the sooner you start, the better. You don't want to leave long gaps. It leaves you open to being out of status and issues to pop up. But it's not a big deal. People do it all the time. What problem I see is people get married after the 90 days. Now, this is fixable. If you don't get married within the 90 days, you get married after the 90 days, then you could just file adjustment of status, but include a Form I-130 petition for alien relative and just do a whole marriage-based green card from new. And so that's possible. It's fixable. But I have problems where I see people, especially when they file their own, they file for the adjustment of they get married after 90 days. They file for adjustment of status. At that point, without the I-130, showing that marriage is real based on the petition, and it gets denied for that, and it don't move forward. So if you get married within 90 days, you can file for adjustment of status and get the green card. If you get married after 90 days, you still can get the green card, but you have to have a petition for alien relative, more paperwork with it. I know it sounds kind of confusing. That's why you should have a lawyer with you just to talk with you and work your way through it. So those are some 3 important things I wanted to mention. And you know what? I'll throw a bonus in there as well. And the bonus is this. You have to at least have seen each other once in the last 2 years before even starting this process and submitting Form I-129F. So when you're about to think about a fiancé visa, one of the main requirements, other than it has to be a U.S. citizen, not a green card holder filing for you, is that you have to have met each other once in person, physically, in the last 2 years, and to be able to document that. And sometimes people aren't able to document it, or they can't see each other. So let's break this down further. The way I like to do it, especially if clients come to me with plans to see each other before we file, I say, meet up somewhere, get a newspaper, almost like you're a hostage, and take a photo with the newspaper to show the date and the location you're together. But also, you have flight tickets to show you what travel to that country, or you both flew somewhere, have photos together, obviously, all that kind of stuff. And they're usually understanding of it and they accept it. But sometimes people have not met each other in the last 2 years. They file, well, that will get denied. There's no way around that, except for minor exceptions. And the exceptions are twofold. One is if someone has some sort of religious belief that prevents them from seeing their fiancé before they're getting married. There's very few religious and cultural traditions that require that. But if you're able to document it well and prove it, it is possible to get the fiancé visa case started, the Form I-129F, and approved. But be prepared for longer delays. So I really recommend people just see each other. It's far faster and cheaper than dealing with requesting a waiver if it's possible. Now, I said there's 2 ways to get the waiver. One was if you have some sort of religious or cultural reason. Secondly, if it's physically impossible for you to meet. And again, this is kind of difficult to do and prove too. I've done it before, but again, from dealing with it, it takes a long time. In the case I recently did, this gentleman who was a U.S. citizen was so sick he couldn't even leave his house physically. And we were able to get doctor letters to do that. And his fiance could not get a tourist visa to visit the United States. They kept denying her. So she couldn't come visit him to take care of that meeting requirement in the last 2 years. And so we show proof that he can't leave his house. He can't even drive to Mexico, have her fly to Mexico. And she can't fly out here because she can't get a U.S. visa. Got that documentation together, submitted it after some back and forth. It took twice as long as it usually does, but we got it approved, and she was able to get the fiancé visa, come to the United States. They got married, and it was a bad story after that. The gentleman unfortunately died like the day after marriage. Sorry, it's a horrible situation, but at least we got the waiver and they got to see each other and get married before the gentleman was passing. It's a very sad story. But the world has all sorts of things happening to it. So these are the stuff I wanted to break down with you and let you know about the K-1 fiancé visa. I'm going to do another video about but I usually do not recommend people do the fiancé visa. It's a lot of extra paperwork, a lot of extra fees, a lot of extra headache. And so my recommendation 9 out of 10 times, and I would need to review your individual case to see if I could recommend this or not, is to just fly out and try to get married and do a marriage-based green card. That way when your spouse comes to the United States, they fly in, they immediately have a green card, immediately have permission to work. If you're doing a fiancé visa, once the person gets the K-1 visa and flies to the United States, they still don't have a work permit. They may have to wait 8 months. Now with coronavirus, the interview is getting pushed back, sometimes a year, 2 years before they get their green card. So it's a big headache through the fiancé visa, a lot more steps, a lot more interaction with the government that we try to avoid. So usually I do recommend just getting married, but it's a case-by-case basis, depending on what the people want to do, what their plans are, and what it works for them. That's why I always say schedule consultation. Call my office, email me at info@jqqlaw.com. We'll schedule a video session to see what's going on, what's appropriate for your case, and how to plan it out, and try to spot issues that could be problematic at the beginning so we avoid surprises later on in the middle of the process. Because this stuff takes so long, and I know you want to be with your loved one, really plan it out so some surprises don't come out later that cause delays that we don't want to have. So I hope that information helped. Please download the Ultimate Marriage Green Card Guide and get that sample of that intent notice and more information about the process. Then, call my office, schedule a consultation. We can discuss it in private all together. My email is info@jqqlaw.com, and the guide is at www.marriageimmigrationlaw.com. Until next one, have a good one. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.